Hello, good afternoon, and welcome to episode number 22 of At Your Service with Haber and Martinez. As you can see, Martinez is not here yet. He is on Cuban time and he is running late, and he will show up as soon as he gets here. In the meantime, we do have our special guest, Denis deVlaming. Denis is off to my right. You can see him there. Denis, good afternoon. Thank you so much for joining us.
Welcome.
We've entitled this episode, "Notwithstanding some unethical lawyers, legal ethics is not an oxymoron." And basically, that's going to be the subject of today's discussion. More or less, is going to be legal ethics, and how it applies to the everyday practice of law and some common pitfalls. And Denis, who is a hands down expert in this area, a lecturer, a presenter, professor, and very skilled and board certified criminal defense lawyer, has probably forgotten more about ethics than most of us attorneys ever knew. So we're very happy to have him here. We're very eager to have him here, and very grateful to have him here. So thank you, Denis. Before you start, I just want to throw one quote out there, because I was looking for interesting quotes on ethics from people who are way smarter than I, which is pretty easy to find. But an apropos quote is a little more difficult. It's finding that diamond in the rough, right? So I found one from Potter Stewart that says, "Ethics is knowing the difference between what you have a right to do and what is right to do." And I thought that was pretty appropriate. When I talk ethics, I usually think to myself, as a kind of joke, whatever it is that you kind of feel as that guttural instinct, like you want to do the opposite, and that's the ethical path. Yeah, right? So you get that $1 million check in the mail settling your client's lawsuit. Do you take that trip to Europe, buy that yacht, or do you deposit in your trust account and wait for it to clear and then turn it to your client, right? The thing you least want to do is usually the ethical thing to do. Anyhow, enough of me. Let's talk a little bit about you and with you. Thank you again for coming today. I really appreciate it.
You're welcome. You're welcome. Just as an aside to what you said, when I was a kid, there was a comic or a cartoon on the TV, and it would be somebody that had to make a decision. I won't say ethical decision, but an ethical type decision. And in that cartoon, there would be a little angel that would come up and hover over the person's head, and they'd say, "Now don't do that. That's not the right thing to do." And then it would go away, and the little devil would pop up and say, "Screw that, go ahead and do it because you want to do it. It's be fun." So you're right. We have those kind of dichotomies of the little voice inside of us that's really telling us what the right thing to do. And usually, unless you're patently unethical, lawyers know the right thing, whether they do it or not. They know what's ethical.
Actually, we're gonna get into that in a little bit, because I'd like to talk a little bit about the Kyle Rittenhouse trial, since it's fresh on everybody's mind. And I think that there are some real good illustrations on all three quadrants of the trial playing field. Most people are aware of the judge teeing off on the prosecutor. Some people may have some feelings as to how the judge did that, or whether it was appropriate for him to have done that in the first place. And then, of course, you have the prosecutor himself, who made an awful lot of headlines during the course of that trial. Some of the things that he said and did, whether it was commenting about the defendant's Fifth Amendment privilege, or providing videotape evidence in discovery that was subpar to the evidence that he planned on introducing, or whether it was pointing the firearm at the jury with his finger on the trigger. Those types of things. And then on the defense side, I learned over the weekend, I guess this is still breaking, and I don't know if it's fully out or not, but there are some issues potentially with the defense in terms of the fact that apparently either Fox News or Tucker Carlson, or a combination of Fox News and Tucker Carlson, apparently paid for, if not all of, a large portion of the defense, with a quid pro quo of having a camera crew embedded with the defense team. Not just during the trial, but during defense strategy sessions, meetings, stuff like that. So maybe we can dig into that a little bit later and try and talk about that. In the meantime, let me just ask our producers if I understand Martinez is in the in the room waiting to be let in. So if you guys could take a look and please let him in when you get a moment, I'd appreciate it. Anyhow, let's talk a little bit about why are there lawyer ethics? What are lawyer ethics? Why do they exist? Why do we even have them? Oh, there's the poster child. I just answered my own question. We have it because of Martinez.
I don't think so, my friend, but I am down. I was thinking of something that I think would be really, really fun when we get to that section to talk about the scenarios of ethics, and let me play it real world live like a game show. Let me see if I can guess. Is it an ethical violation? Is it not an ethical violation? And maybe our thought process and see if people understand it. Sometimes it's not as easy as it's not as logical, I would say, as most people would think. Am I right?
Well, you're right and you're wrong. I think most of the ethics are not technical in nature. Some of them are where you say, gee, you know, if I'd have known that, I'd have done something. But generally speaking, you know, people call me all the time and say, you know, can I run something by you? And sometimes when they do, I want to say, well, you ought to know what you should be doing, you know.
Right.
But I'll be happy to answer the question. So, I think generally speaking, ethics are, what you do when your mom is not looking. So,
right.
I'll add something interesting here from my own personal experience. The Florida bar has an ethics hotline for lawyers, 800 number, and I guess anybody can call, but there's a dedicated line for lawyers. And so lawyers can call, and they've very wisely encouraged lawyers to call by making the calls anonymous. So you can call, you don't have to give them your name, and they're not going to use anything that you say or ask against you in any future proceeding. It's truly designed to give advice. And they have on-staff attorneys who are intimately familiar with all of the disciplinary rules and all of the case law and everything else. So these guys, I mean, it's amazing to me how they rattle off answers and they spout out,
But I beg to differ on one thing, Michael. They're very crystal clear. They do not give advice, which I understand why they do it, but it's my pet peeve. They point you to the rule that addresses
the
issue.
But you're right. So semantics, you're right. They don't say you do A or B, but they do interpret or give you the interpretations of the appropriate rule for whatever it is that you're calling on. They give you guidance, is what they do.
They do.
And so I have used that many, many times. It's like a go-to for me because I shoot things by people like you, Ed, or Dennis, or other lawyers that I know and trust. But at the end of the day, when I call the Florida bar, they're giving me case law. I mean, they are actually citing rules.
Yeah, and to their credit, if it's something that you can do, I've used it many times. Even when I think I'm 100% sure of what the answer is, I always call just to make sure. And I can say this. Several times they've told me, oh, you can absolutely do that. It's when they don't tell me that I can't do it, that it usually means you can't do it. They just don't come out and say you cannot do that. They leave it up to you. But anyway, why do
we have the rules of professional responsibility? Why does anybody care about any of this stuff? Why is it important?
Well, it might be as simple as defunding the police. I'm not so sure it's a good idea not to have a police department. So I think what it is it's gotten to the point where they say, here are the rules, here are the laws, and you will follow them. And so we don't want you down the road saying, well, gee, I didn't know, or gee, that's a violation, or gee, I'm sorry, I won't do that again now that I know. So they're just laying it out, and I think they do it so that there's no mistake in the profession what you can and can't do.
But there's no excuse of ignorance to a professional rule any more than there is to violating a criminal statute, right? I didn't know that was a crime. I didn't know that was ethical violence. It's not going to fly.
Well, the problem with an ethical violation is if it's strong enough, you can lose your license. They can say that you're not, you're not to practice law anymore. So, and then they can point to what you should know, and this is what governs you. It's on the books. So, don't say you didn't look it up. It's kind of like ignorance is, no excuse and so forth. So I'm not so sure it's a bad idea. I think it's a little insulting that they have to tell us. we should know this stuff,
Some of the stuff I agree with you, Dennis.
Well,
Some of the stuff
we
is
should,
pretty obvious.
but everybody has a different moral compass, and we all look at life through different prisms and different life experiences.
Go ahead, Michael. Finish. I'm sorry.
No, I was just going to say, I think that having guidelines and having certain things that are common sense, they should be common sense to all of us, but they aren't necessarily so. And even worse is, in any given moment, as humans, we're all subject to the same frailties as anybody else. We could be in a good mood or a bad mood. We could be in a financial crunch. We could have anything going on in our orbit that's distracting or overpowering or, sucking us in beyond our ability to control. Drug problems, alcohol problems, gambling problems. Lawyers are people, believe it or not. So
that's what they say. But can I point out an example of what I meant by sometimes it's not as easy and obvious. Some of these are easy. Some of these are clearly obvious. But take, for example, as a criminal defense lawyer, when your client says, I really want to testify, and you know that your client is going to testify and lie. Now, we know we're not allowed to let anybody lie, and that should be a no-brainer. And even if you don't know that, you're told the rules of ethics is you cannot put anybody on the stand that or have a reason to believe is going to lie when they testify. But there's the conflict now of the attorney-client privilege. What do I do if my client wants to testify? Do I call a sidebar and tell the judge, I don't want to let my client testify because I know he's going to lie? Well, then I just violated my attorney-client privilege. But by the same token, I really can't allow him to testify because I know he's about to lie. And that's one of the examples I was going to say, Dennis, that sometimes it's not quite that crystal clear as to what is an ethical violation. And that's one, for example, in criminal law that I've seen a couple of lawyers try to handle it certain ways. I remember sitting in a situation where a judge was trying to give a simple seminar. It wasn't really anything, nationwide. It was just for local lawyers. And I won't say who the judge was, but I felt that what the judge said was incorrect. I thought it would violate the attorney-client privilege. And I thought, but it is a difficult question. So how would you handle something like that? What do you suggest a lawyer do in a situation like that?
Well, actually, it's covered. Actually, that's been litigated with the bar, and they do have an answer to it. And if the client is going to lie and he says, listen, I am going to testify because I'm going down and you can't stop me. And, the bar says the first obligation of the lawyer is to try to dissuade the client from committing an ethical violation. Okay, let's assume you can't dissuade him because he's looking at life and he's going to lie and he's going to do whatever he wants. The law says that, the regulations say you have to then say, Your Honor, at this point in time, I would like to approach the bench. And you approach the bench and you say, Your Honor, at this time, for attorney-client privileged information that I have, I hereby move to withdraw as my client's counsel. Now, we all know he's the last one to testify in a trial. Do you think that motion has ever been granted? No. Does the judge realize that you say, I have an ethical issue before my client, I'd like to withdraw, red flag, red flag, red flag, got it. Then what the bar says you have to do is, yes, you have to call the client. Okay, you've tried to dissuade him. So he takes the stand and you say, Mr. Jones, do you have a statement you'd like to make for this jury? Yes, I do. What is it? Narrative. Now, a lot of times the state will say objection, narrative. The judge is going to say overruled. And then when he's finished, you say, are you finished? Yes, I am. Cross-examination. Okay. Then
I feel great.
The caveat at the end, though, the lawyer may not mention his testimony in final argument.
See, as a lawyer, I feel great.
What if the prosecutor?
If I may, Michael, if I may, just briefly, the judge in that situation, and it was about 15 years ago. I thought the same thing. That was my suggestion. She said, "No, you have to come sidebar. And you have to tell the judge that your client's going to lie."
No,
said, if I do that, am I not violating his attorney-client privilege? I can't do that.
Yes.
And I said, if I come sidebar, mine was a variation. I said, if I come sidebar, I said, Your Honor, my client wants to testify, and I don't feel comfortable doing a direct examination on him. So I'm going to let him testify, but I'm not going to do a direct. I'm simply going to ask him what happened and step back. And she said no. And I was like, I think she's wrong. I don't think that's right. So I'm glad to see the Florida bar actually has litigated it. And I think that's what I thought was my legal gut instinct. Go ahead, Michael. I'm sorry.
I got a lot of questions here. So first off, how do you know he's lying? Okay. I mean, I don't have too many. And our clients, obviously are different people, because I don't know that I have ever had a client say to me, all right, I'm going to lie. Okay.
You've never had a client. Hold on. I got to defend myself. You've never had a client say, what if I get up there and I say?
I have had clients say that, but I've never had a client say to me, I'm going to lie. Okay. Now, I've had clients that I
help me out here. When a client says, what if I get up there and I say, what he's saying is, what if I get up there and I lie? They never come out and say, hey, I'm going to lie.
I don't agree with that. I'm not there to. I don't think it's my job to judge the client. It's my job to use common sense and prudence. So if my client tells me a version of events, okay, if I'm interviewing my client tells me this is what happened, then it's X. And then we're getting ready to go to trial and we're trial prepping for testimony. He gives me a whole different story. I'm going to question him about it. That's where that discussion is going to occur. But I haven't had clients say to me, although I have had clients say more than once, I've had them ask me, what is it that I should say? Or what is it that you want me to say? That's a separate kind of linked issue. And then the more common one that I've gotten, which really is easy for me to deal with, is the client who says to me, I've got 6 friends and 14 cousins who will say anything we need them to say. Just tell me what you want them to say, right? That is suborning perjury. That is creating testimony.
Well, let's ask the expert. Let's ask the fan on the show. If a client says to you, in Michael's scenario or my scenario, and what if I were to say X? My usual response is, only if it's the truth. You can't lie about anything. But we all know what he's talking about. Or let's look at Michael's scenario. He says one thing on the day of the interview throughout the whole process. Maybe for whatever reason, he now comes and says, hey, I want to testify and I'm going to say this. What should the lawyer say, Dennis?
Okay. And let's take that. All along from the first interview, he's telling you what happened. He's telling you what happened. He's telling you how. Let's tweak this a little bit and say you're sitting in trial. You're in week 2. He listens to a critical witness and goes, oh, shit, I've got to have an answer for that. I've got to have an answer. And he turns to you and says, now what I'm going to say was, I wasn't at that store, or I didn't get in that car, or whatever. And that's not what he's told you all along. Okay. So, he's telling you he's going to lie to make it up for the witnesses that he's just heard. Can't put him on. But let's tweak it a little bit, because you say to him now, I can't put you on the stand. You just told me you're going to change your testimony. What if he looks at the lawyer and says, okay, I won't.
But Jimmy will.
You call him as a witness, and as you're doing the direct, you're going, oh, he got me on this one, because now he's deep into what he told me isn't the truth. The question then becomes, what does the lawyer do in the middle of it? Does he then go to the bench, go to the narrative? Does he finish?
And Dennis, if I can interrupt you, for the non-lawyers, the reason Dennis is saying it with such intensity is because we all know there's attorney-client privilege, right, Dennis? That's what we're talking about here. What do you do now with the backdrop? Remember, for the non-lawyers, there's an attorney-client privilege issue. So what do we do, Dennis?
Okay. Now, do you know when the attorney-client privilege is abrogated?
No, I do not. I did not.
Twice, on 2 times. Number 1, if he comes in and you're defending a guy who's beating up his wife real bad, and he says, well, don't worry, my wife's not going to testify, so I'm going to be found, I'm going to be, the charge will be dismissed. And you say, gee, that's funny. She just called my office and said, I can't wait to testify against my husband tomorrow. And he says, I got to go. I'm going out and I'm going to kill the BITCH. Okay. Right. The law says attorney-client privilege is all off. Got to call the police. Got to call the police. I didn't know that. The other one is a little bit more tricky. and that is a fraud on the court. If somebody is going to commit a fraud on the court, the attorney-client privilege is abrogated. So now you're going to say, well, wait a minute. He just told you he was going to lie. Isn't that a fraud on the court? And it gets real close as to whether or not you do what I talked about by putting the client, on doing a
letting him narrate.
Right. So, again, you try to dissuade. I'm usually pretty successful at it because what I do is when he tells me he's going to lie, I'll take some time and I'll go into I'm a former prosecutor, as you guys might be too. I'll go into my cross-examination. And by the time I'm finished in private, I say, you see what he's going to do to you? And that was off the cuff. And he goes, yeah, you got me.
Well, I got another tactic. I usually look at him and say, I know this isn't going to come across as humble as Michael is so used to me being. But I usually look him right in the eye and I say, listen, buddy, I'm good. We don't need to lie. I'm that good. Okay? Right. We can get through this with the truth. Tell me the truth. Now let me do what you hired me to do, which is work with the truth.
What about where the client gives you his version of events and he's consistent? But you believe in your heart of heart that version of events is bullshit.
No,
you are convinced the guy, right? So his truth is what you have to accept.
Correct.
No matter how bizarre or idiotic it may appear. So I get, every now and then you'll get a client who says, oh no, they got the wrong guy. Well, how do you know they got the wrong guy? It's because I wasn't there. What do you mean you weren't there? Where were you? I was at my cousin's. Okay, who's your cousin? Jimmy. Jimmy what? I don't know Jimmy's last name. You said Jimmy's your cousin. Yeah, well, Jimmy's my cousin, but he's not really my cousin. And they give you this convoluted story, and whatever it is. So, for that reason, what I've done in my practice is I never ask the client to tell me anything. I don't want to hear a word from my client until after I've read the police reports. I want to know what the case is about before my client tells me the story, because it's my way of gauging the reasonableness of the story. I mean, I'll try and look at it without judging one way or another, except seeing, is there probable cause? Are there obvious factual or legal or procedural or substantive mechanisms or loopholes or technicalities that jump out at me that I can take advantage of? Do those things exist? And then is the client going to supplement that information with information of his own that gives me a case, right? So
I do the same thing.
Kind of look at it.
I do the same thing for the same reason. Well, I do it for two reasons. One is for that, because I want to see before I even get into them telling me their story, I can avoid all these issues if I can look at it and say, wait a minute, there was absolutely no probable cause for the stop. So I don't have to worry about what happened after the stop. Doesn't matter to me. There's zero probable cause for the stop. So this is what we're going to argue. But now if you want to tell me your story, fine. The other reason I do it is because it impresses the hell out of them. I too was a prosecutor, Dennis. And it impresses the hell out of them when I say, okay, they didn't write this on the A form, but I bet you the cop did this and this and this too. And they're like, how did you know that? Because I've read thousands of these, and I know this is bullshit. He couldn't have gotten here from there. Something happened in between. So this I know is complete bullshit. So tell me what really happened. So
how do you do it, Dennis?
Actually, I'll have to be the Lone Ranger on this. And when I sit down at my first, my first meeting, the first thing I tell them is whether they hire me or not, there's an attorney-client privilege. So if you end up not hiring me, whatever you tell me, stays in this office. And as the U.S. Supreme Court said, it even survives death. So even if you die, I can't tell your wife and what have you. So what I do, Mike, to be honest, when I sit down, I tell them, I need to know the truth, because you're going to be pointing me based upon what you're telling me. This is a mitigation case, with the exception, now don't forget, with the exception of legal matters like stops and things like that. You're going to learn that from the reports, whether you have. But as far as the guilt or innocence, I sit down, want to know everything. And then I figured I'm going to start my mitigation because you just told me on tape, you confessed, they got a surveillance tape, you did this, and whatever. I might be a minority, but
no, but that's good advice, because I do supplement. And again, because we've got, I'm assuming non-lawyers watching, I want to bring up a real world example. I know they love the war stories. I don't know if this ever happened to you, but I was an economic crimes prosecutor here in Dade County. I was in narcotics. and then I was in economic crimes. And I represented a woman. I won't get into too much of the details, but I represented a woman on a white-collar crimes case. And from what she told me, which I, again, thought from my experience was not believable, what she told me was that she didn't steal $150,000 from the bank. She just kept stealing the same $10,000 and putting it in other people's accounts. So she would take 10 from this person because she was covering her ass. And when that person called and find out, because she was the one in charge, she would then take 10 from another and replace it to that. So I said, are you sure that's what you're doing? Because God bless the prosecutor. He's a sweetheart and a very nice man, but he has no clue what he's doing in economic crimes. And if that's your defense, I can bring the $150,000 down to 10. But in order to do that, I'm going to have to teach him how to find the evidence. Are you sure? Are you 100% sure? Because I am about to teach this man how to catch you if you are lying to me.
Right.
You know, you're laughing because you've done this. We all laughing here because you know what happened, right?
Right.
Came back to court 30 days later, excited how he had found another $250,000. Thank God he was there, and he was an honorable man. And he told me, I'm not going to do this because you're the one who taught me how to do this. So I'm going to keep the 150. But that's a lesson for you guys out there. You need to trust that your lawyer is the person who's going to help you. And if you trust them, you've got to tell them everything so we don't step in bear traps politely or bear shit when we're talking to the prosecutor.
Yeah. Well, don't forget, they're paying us, and they're paying us good money. You know, they're not public defender clients, which don't seem to be anywhere near as grateful as the clients that we have. That generally speaking, if they're paying us a lot of money and you sit down and say, listen, you know, you play client, let me play lawyer, tell me everything so that I can give you the best legal advice, you know? And most of the time,
let me run with that for a second, because I want to talk about this is a very common occurrence, and for non-lawyers out there and potential clients out there, not everybody has access to funds, and especially if you're in custody, if you're not bonded out for any reason, and you need representation right away, some third party has to hire a lawyer for you because you can't write checks from the jailhouse cell.
Right.
You can't transfer funds from the jail.
No, but they can give you cartons of cigarettes. You don't barter, Mike.
Not anymore. You can't smoke in jail legally. So third party payment. All right. Ed gets arrested, and his wife pays me. There are very clear rules as to the lawyer's ability to accept funds from a third party, and there are very clear rules as to the third party's rights as regards the case that they are funding. Would you care to expand on that a little?
Yeah, and as we were talking about it before, Mike, my contract says the same thing your contract says, and that is the client, even the non-paying client, is the client that calls the shots. The attorney-client privilege is between me and the client. If the client wants it to go a certain way, to trial, to a negotiation, the client rules. The person putting up the money does not have a say in the case itself unless the client, and I usually have him, put it in writing or like initial the paragraph, says that it's okay to share information with that person, with my family, or whatever, whatever it is. But they are distinctly different obligations when it comes to the person paying and the person you're defending.
Here's another one for you that we get very often. You have a client who wants to control and steer the course of the litigation, right? You get hired on the case, and the client says, all right, I want you to do this, and I need you to do that. Whatever you do, don't do this, okay? The client is the boss in the attorney-client relationship. They hire us. We serve them. But that doesn't mean they have absolute control over what we do as a lawyer, correct?
Correct.
Care to expand?
Yes. I had to make a little note, so I made sure I got both of them. Actually, you're somewhat correct in what you just said. The Florida
I feel like I'm back in law school. You're giving me PTSD. We were never right, even when we were right. We were never right.
I'm an adjunct professor at law school, so
Damn it.
I can't take that out. But
That's okay, Ed. You're gonna book this for episode 22. You'll get the book.
Yeah. The lawyer actually makes all the legal decisions. If a client says, I want you to call that alibi witness or something, and you say no, it's no. I know what you say. Well, wait a minute. And a lot of us would say, okay, it's your funeral. I think they're going to eat this alibi witness alive. But if you want me to do it, I'll do it. You don't have to. There's only two things that you are trumped on. The client trumps the lawyer on one, whether to testify at trial. You cannot overrule that. Another is if there's an offered negotiation, you cannot say to the prosecutor, we reject it, without the client saying I reject it. So they trump us on those two. But as to the trial and the decisions, the Florida bar says this is why we went to law school. This is why we have the talent. We know better than he does. And then sometimes it's a combination. I'll either talk him out of what he wants to do. If he's insistent, frankly, I've done it, and then if it doesn't work, I look and go,
told you so.
So I agree 1,000% with that. And again, I revert back to my own CYA mentality, which is I draft up a document that says, if you want me to call Susie, it's against my legal advice.
Yep.
Please sign here telling me that you don't care about my legal advice in this particular instance, and I am to call Susie, and I'll do it. Because, again, as far as I'm concerned, if the client wants to commit suicide against good advice that's been offered verbally and in writing, I mean, and how much more do you really have to say to kind of get the point across, right? I mean, if I tell you don't do it, and you still say I don't care, and then I present you with a document as your lawyer, the guy you're paying, that says, all right, I'm telling you not to do it again, and if you want me to do it, you need to sign here so I can protect myself against your decision making.
But these are like the people, Mike, that want to represent themselves. I mean, we all know how foolish that is, but they think they know more than we know. They don't trust us. Now, this is a very small minority, but very, very small number of people that fit in that category. But there are some that think they know better than we do.
And look, I don't blame them. I used to when I was younger, but as I've gotten older, I've realized it's very difficult to blame them because there are so many people out there. I mean, even if you watch the media, I see pundits. You want to just have your mind blown. I saw a allegedly a Princeton law professor today say, and I won't say who it is, but obviously it's a trial that was in the media, saying that the jury had found him 95% guilty beyond a reasonable doubt, but 5% on self-defense.
Are we talking about Rittenhouse?
Yeah. Princeton.
Okay, we're going to talk about
literally
Rittenhouse.
Said that. I'm like, how does he even say that?
He's not a lawyer. Certainly
he
not.
Said he's a Princeton law professor.
Not criminal law professor. He probably teaches wills and trusts.
Dennis, even a civil lawyer. Even a first-year law student knows that is not the standard.
Right.
Come on.
Right.
That was bizarre. I didn't know we were going to talk about it.
We're definitely going to talk about Rittenhouse. Before you got on, I brought up all three, areas of the trial, the defense, the prosecution, and the court, all of which have something interesting in terms of ethics to discuss. I think it's just, it's fascinating. I mean, you could almost take a sub-career out of doing this. And some lawyers do, right? And in fact, Dennis, I think we talked about that earlier. There was a point in time where you did do defense work for lawyers who were accused of ethical violations, correct?
Correct. Yes.
And you don't do that sort of thing anymore, but that's pretty challenging because I got to tell you, to me, I treat every criminal case the same. I don't care if it's a misdemeanor or a murder rap. To the client, it's all serious. The repercussions, the consequences, the collateral consequences, all of it can be damning, lifetime damning. Obviously the stakes are higher in a murder case than a misdemeanor case in terms of fines and penalties and incarceration, but the effect on the client can be just as pronounced. So as a lawyer, when we get called in front of the bar and they say to us, all right, Haber, we're calling you out on this. Somebody said that you did that, whatever. all of a sudden that's like my liberty now. This is like my murder case or my misdemeanor, right? Because my license is in jeopardy. And so as a student of the law and as a believer in, we did a show last week on adages and idioms, and one of them is he who represents himself has a fool for a lawyer, right? So if you go up against the bar when you are the accused solo pro se, you're an idiot. You're not just a fool, you're an absolute idiot. And there are lawyers who specialize in this. So kind of like we were talking about earlier, the lawyers from the bar who you can call and ask for an ethical opinion. There are lawyers who do this just like I do criminal law, just like all three of us do criminal law. This is what they do. So for some period of time you did that. You must have had some interesting experiences doing it.
Yes, and most of the times the way that we handled the case was by mitigation. There were some BS cases that were brought. We could get them knocked out before they even hit a committee. But if they went in front of the committee after the finding of probable cause, a lot of times it was damage control.
But that's the same thing in criminal court, right? Because most of the time, we don't go head on and just say, all right, you know what, screw you, Mr. Prosecutor, we'll see you in trial.
Right.
I mean, even if we say it, most of the time what we're doing is setting ourselves up for a good plea offer, or for statutory mitigation, or for some ability to reduce the client's exposure. But just like they say doctors are the worst patients, lawyers are the worst clients.
Probably the worst client. Yeah, you are right. I don't know whether you guys down there remember a guy named Robert Mad Dog Merkel. He was a United States attorney for the Middle District back in the 90s and stuff. And anyway, he got charged with a misdemeanor battery. It went 3 weeks. 3 weeks
Wow.
For a misdemeanor battery. I cross-examined the alleged victim for 2 days. Merkel was the one that charged Noriega. So he had the FBI out in front of his house and so forth, to guard him because he was going to be murdered. He had 9 children. He and his wife had 9 children. So we had to bring all in what he feared, on the basis of who he was on this battery charge. But anyway,
9 kids.
But let me tell you,
prosecute anybody.
That was the worst experience of my career. I'd be in the middle of a cross-examination. I'd hear, psst, psst, hey, and I'd have to go over there, lean down, and I'd go, Bob, I'm getting to it. Bob, I'm getting to it. Let me do it. Okay. And then 2 minutes.
Oh my God.
So yeah, lawyers are the worst.
They're the worst. Oh my God, that is funny. I want to go back to one thing briefly. You said, I've had situations where, Mike, I'm sure you have too, where I'm sure if you and Dennis, I didn't realize, I keep forgetting you did criminal. When the prosecutor, you get that crazy prosecutor who comes up with the most ridiculous, plea offers, first time offender on something minor. He was like 10 years prison or something. And you got to make that phone call to the client and be like, I got to tell you the offer.
I got to do this. Yeah, right.
I don't know. Just bear with me. He wants 10 years. What? I got to do it. I got to tell you, this is what he wants.
Right. But ethically, you got to tell him what the deal is.
I got to.
You can't reject it out of hand. The client's got to say no.
What if the client tells you right up front? And I've had clients, not often, but I have had clients who have said to me right up front, there is nothing that a prosecutor can offer me shy of a dismissal that I will accept. I will not take diversion. I will not take a plea to anything. I am going to trial, period, paragraph. If I'm given that instruction by the client and the prosecutor tells me he's offering my client 10 years, then what?
Oh, rules haven't changed. You've got to pick the phone up. You got to pick the phone up or have the meeting with the client and say, listen, there's been a 10-year, offer. And of course, if there's a 10-year offer, that means the guy's looking at 30 or, right. Obviously more than 10 years, right? And the reason you got to do it again is because he goes to trial, he gets convicted, he gets 30, and then he finds out he could have had 10. So he goes after you. Now you still got to tell him.
Yeah, I do. Right. And I do, Michael, I do what, probably what you do. I'd say, listen, I know you told me, but I flat out tell them. I say the Florida bar requires me to tell you every offer.
Exactly.
Right. So here it is. What do you want to do?
Deflect and blame the bar.
Absolutely. Listen, if I was President Trump, I would have deflected and blamed Fauci for everything from day one. Good, bad, or indifferent. I would have been like, I'm listening to Fauci. What do we do next? When all hell broke loose, I would have been like, oops, Fauci.
Let's not go there now, you know.
Fauci.
Yeah, no.
But President, you said Fauci. But you Fauci.
Okay.
Let's talk a little. Let's talk a little Rittenhouse.
Okay.
I don't think anybody on there can't be too many people that don't know who Kyle Rittenhouse was and what this trial in Kenosha that just occurred was about. And I don't really, again, we're not here to get into the politics of it or anything like that. But sticking to our ethical discussion, there were. Let's start with the prosecution. There were numerous allegations by the defense against the prosecution. Now, listen, this happens in virtually every case, right? At some point in a trial, a defense attorney is going to object to or complain about something that a prosecutor did or didn't do, and vice versa, right?
Sure. Right.
It's almost inevitable. It's part of it.
It's given. Yeah.
So there were a couple, and let me just get to my notes, but so let's go to one that was really, I thought, interesting. One of the charges that Rittenhouse had was possession of a firearm by a minor, a specific type of firearm. And as it turns out,
short barrel.
Right. And as it turns out, anybody who took a look at that firearm with a tape measure would have known that the firearm did not fit the element of the crime, and therefore he could not have been charged with it, which is the reason that the judge dismissed that charge.
Right.
So ethically, either the prosecutor knew and didn't care, or didn't do their homework and didn't know what they charged versus the evidence that they had in their care, control, and custody. Ethical violation?
Well, I don't know enough about the reasoning, that he had. The first thing I tell my students is the very first thing you do when you take a criminal case, and I don't know if you guys do this or not. Most of the times I go to the jury instructions. I find out what they have to prove. What the jury is going to be told the elements are. 3 elements, they got to prove this. That's the first thing I do. Now, a lot of times if they're humdrum cases, I know what it is. But generally speaking, I want to see what they have to prove. I'll put money on the fact the prosecutor didn't do that. He probably just looked at gun, assault weapon, and minor, and then said, okay, I'm ready.
And here's another, in my opinion, humbly speaking, I think that element, and I don't know if there were any motions eliminated or any pretrial motions, but as a former prosecutor, I mean, I would have done it because I did it that way. But I think a little bit of the onus has to go on the defense here too, because you have every right to inspect the evidence. They could have very easily, right before you pick a jury, said, Judge, as we're laying out the evidence, I want to bring in a private investigator to just measure this barrel.
How about forget right before trial? I mean, this case existed for a year. The information was filed 12 months before the trial started. They knew what the charge was. So that's on the prosecutor's end. Maybe it was negligent or whatever, but the defense end, I mean, that's almost ineffective. How could they not have done that?
Wait a minute, you're missing something. You're missing something. And that is, I'm going to assume they knew all along. As soon as they picked up that indictment or read it, they go, look at number 5. That's out of here. But
So they made a strategic. I
want
the jury to see it.
And then I want to be able to say, you know what, ladies and gentlemen, that guy up on the bench with it threw it out. He threw it out. There's no evidence of it. So you don't know whether or not.
Is that good strategy? Is that good defense strategy? Is that ethical defense strategy?
Sure. Absolutely. So. Why wouldn't it be? It's your client's never going to face it. You know that, right? It's going to get dismissed either in a JOA or before trial if you file it. They may have decided, strategy-wise, we want the judge to throw it out.
Excellent point.
So I don't know.
There's an awful lot of value. There's an awful lot of value to that.
It also makes the prosecutor look inept.
That's right.
That's
right. Like they don't know what the hell they're doing.
There you go.
All right, so let's go on to the next one that I have written down here. there was some question regarding the star witness for the prosecution, the surviving victim that got shot. And apparently there was a bombshell on the stand, a Perry Mason moment, where he admitted on cross that that Rittenhouse pointed his gun at him and shot him only in response to the fact that he at first pointed his pistol at Rittenhouse.
Well, that he lunged at him and put the gun almost right to his head.
So apparently either the prosecutor was unaware of that testimony, or they were aware of that testimony and ignored it, or the witness changed their testimony after they gave it. But whatever happened, there's some question as to whether or not the prosecutor was aware that their witness basically tanked that count by becoming the aggressor vis-a-vis his own testimony.
Don't forget, and your listeners may want to know this too. The prosecutor does not have access to the defendant, doesn't know what the story is. Yes, they have the tape, but they don't have the story of the client. They don't know from the client's perspective, with the exception of the tape, what the client's going to testify or not. So I don't know whether it was something that the prosecutor was totally, thrown off base because the guy had said the opposite and then he submarined him on the stand. But you guys know as well as I do, a skilled cross-examiner can make a witness agree or disagree with things by the way that you conduct your cross-examination. They may have led that guy, and I have to confess, I did see a snippet of that on the news, but I didn't watch the trial, so I don't know. But there may have been some on there where that guy was led into, and you lunged, yes, and before you lunged, you pointed your gun. Yeah, see, I don't know what
I think one thing that we can take from this trial for sure, no matter what, is that the prosecution was severely to use a bad pun, outgunned by the defense. The defense lawyers were far superior.
They did some things I think are clearly unethical. And I don't know.
Well, let's get. There's two more that I have on my notes, and if you have anything else, add it. So the next one I have is right up front. They during cross-examination of Kyle, they went right into his Fifth Amendment privilege to remain silent, and the judge absolutely scolded when.
Oh, we lost Michael.
Off on.
You're back, Michael?
Sorry.
Okay, go ahead.
Had a call come in. The judge went off on him, and we'll get into the judge's reaction for a moment. But the prosecutor, again, this is not a kid right out of law school. He knew not to comment on the right to remain silent. That's, basically probably in the top two golden rules of criminal litigation, right? Yet he did that. I don't know whether it was intentional. I don't know whether it was a mistake. I don't know whether it was a heat of the moment thing. All I know is it happened.
And so we make it crystal clear. It was post-arrest. Post-arrest, Kyle Rittenhouse invoked. And he went into this post-arrest invoking of his Fifth Amendment right in front of a jury. Now, I've been telling, I am shocked at how many criminal defense lawyers I see that don't have a problem with this. When, correct me if I'm wrong, Dennis, this is clear-cut mistrial with prejudice. No judge would be reversed for mistrying the case when a prosecutor goes into a post-arrest Fifth Amendment right. Or am I wrong?
All right. When I was in law school, I wrote a law review article on Harris versus New York. And you guys probably not off the top of your head know what Harris says, but what Harris says was the United States Supreme Court opinion. And it says a person who testifies cannot hide behind a constitutional guarantee to commit perjury. So if you've gotten something thrown out on a Fourth or a Fifth Amendment, okay, and then you're going to testify in your trial, you better be careful. You better be careful that you don't lie such that what you got suppressed doesn't come in to haunt you. So I didn't want to.
But it wasn't suppression. It was the fact that Kyle Rittenhouse invoked the Fifth.
Okay, then you don't do it right. Then it's absolutely mistrial testimony.
And I want to ask you an opinion because I did something years ago as a prosecutor, a narcotics trial.
The statute of limitations has run, Ed. Don't
No,
worry.
no, no. I think, this one I will say who the judge was. She was a prosecutor, a colleague of mine at the time, and I think she's done a wonderful job on the bench. Andrea Wolfson. She was my second chair on the case. She's actually had more experience, but it was my case, so that the audience understands. We were almost equally matched with experience. If anything, she had a little more than me. But in this case,
and she's better looking and better tempered. Yeah, I mean,
smarter.
The list goes on. It doesn't stop there.
There's a lot. There's pretty much nothing.
Suck it up.
There's pretty much nothing that I'm better at than she is. Listen, she had to deal with me. She was my chief for about a year. She had to deal with me for a year, and she didn't lose her mind. That's all you need to know. But we're in the middle of it. We're doing the trial, and then I'm going to do the facts as quickly as I can so we can get to the issue. So the co-defendant, our position was that he was the getaway driver. We had a lot on him why he was the getaway driver. And one of the things that I think would have sealed the deal for me, his defense, and he testified they had no idea that his brother was going in to do a drug deal and that his brother was going to go rip off 2 kilos of coke. Fortunately for his brother, he was dealing with cops, and his brother ended up getting shot as he was running out of the warehouse that he tried to steal.
Oh, boy.
So this guy who supposedly said his brother told him he was driving him to a job interview is sitting there, has priors, by the way. He was a prior convicted felon, is sitting there as his brother, he hears a gunshot at what he thought was a job interview. His brother's running out. About 15 police officers come running out to arrest him. One of them grabs him by the throat, pulls him out of the car, yelling at him, puts his face in the mud, puts his foot on his neck, and says, "If you move, I'll fucking shoot you." Doesn't say a word. Then when they bring him in, nobody has questioned him or anything. They just brought him in. He's still sitting there, never once. And this is what I said to Andrea. It's pretty damning that you never once asked what the hell's going on. You never asked what the hell's going on. You thought it was a job interview. But I looked at Andrea and I both agreed. We thought this might comment on his Fifth Amendment right, and we don't want to mistry the case by pushing the envelope. And we both decided not to ask that question. My question to you was, could I have asked the question?
You can ask that pre-arrest or pre-Miranda. You can ask that question because that's fair game. Once there's been an arrest, once there's been an invocation on the Miranda, bets are off.
Hands off.
Ask.
And here's an illustration for the non-lawyers. Why is it that every lawyer should be incensed about what this prosecutor did in the Kyle Rittenhouse deal? All of us back in the office all thought, you know what? It's just too damn close to risk it. And as you're pointing out, Dennis, I agreed with you. I thought I could have. But
they were well over in this case, they were well past that, well over that line. It wasn't even
a question. Let me ask you, why do you guys think he did it? Why did he ask the question? He had to have some experience. He wouldn't be on TV and doing a case this big.
I don't know. I found out
I think there's 2 reasons. I think
he wanted a mistrial. Maybe he wanted a mistrial.
There you go. There's one of them. That's one. I'm losing. And the other one is, and I don't know whether you viewers know this or not, but the state cannot appeal. If there's an acquittal, it's over. It's over. So a lot of times the state goes, hey, here's a Hail Mary, man. If I lose permanently. So as Mike said, it might be one of those.
That was one of the things I posted. And that way, I thought the same thing, because in that case, then politically, he could blame the judge. He could say the judge was wrong. The judge is the one who let Kyle Rittenhouse go, not me. I did my job.
Don't forget, there's another trial. So there you get to live again.
But not if he causes the mistrial, right? Not if the
No. Well, this gets a little bit technical, but if you move for a mistrial, I move for a mistrial on that basis, new trial. If I say, Judge, he did this because he knew he was losing, and this was just a whole bunch of things that he's done to make me move for a mistrial, I ask that it be chargeable to the state. If the judge grants it and says mistrial chargeable to the state, it's over.
Right. They called it with prejudice. Let me hit the last couple of points because we're running short on time here. There's only one other issue for the prosecutor, and then I've got for the defense and the judge. The last one I have for the prosecutor is that apparently they provided a significant piece of evidence to the defense in the form of a video. yet they gave the video what purported to be a significantly lower quality version of the video than the one that they actually used at trial. So in other words, there was much more clarity to the one that the jurors got to see that the defense lawyers never saw until they were actually in trial, because their video was subpar. So that was another issue, and arguably falls into the same category of maybe it was a mistake, or maybe it was just another way for the
an important point. The defense argues that the state says they didn't know they had that better quality video until they were halfway into the trial. The defense argues they knew exactly they had it and they withheld it from them. That's the ethical question. Whether or not, if they did know and withheld it from them, the state would say, oh, we didn't know until 3 days before the trial. So that's really the ethical question.
Well, and don't forget, I'm gonna be a little bit more towards the prosecutor in this particular scenario, and away from the unethical issue. I think when people in your office, in the state attorney's office, when they do copying stuff, the lawyer doesn't do that. The lawyer doesn't look at the copy that's been made and look at the two and say, yep, it's really good, here you go. So they don't really know what's on the defense lawyer's desk, the quality on the desk. They don't know it. They cut it and went there. So I'm going to give them the fact that they may not have known. Now, what's the remedy? The remedy, of course, would be if it's critical. If the copy they gave wasn't just subpar, but you can't see certain things, there might have been a mistrial granted by the defense.
Let me, since we're almost done here, so let me just hit real quick on the issue with the defense and then the judge. So apparently with the defense, it's breaking news now. I just saw it for the first time yesterday, but apparently one of the defense attorneys was on CNN Cuomo's show over the weekend and told Cuomo that Fox News and or Tucker Carlson and Fox News apparently paid for all or a significant portion of the defense, but they did so in a quid pro quo fashion. And the quid pro quo was they were able to embed a filming crew with the defense so that they could do a documentary after the trial. And so that's being produced now, but apparently the defense lawyers had some issue with this camera crew being embedded with the defense team, particularly during what were otherwise private meetings between the defendant and his lawyer, except you have this camera crew there filming. So I guess I'm sure they had some understanding that nothing was to be aired until after the trial was over and blah, blah, blah. But in the meantime, is there an issue with the lawyer? If the lawyer feels strongly enough about this, does he have the ability to say to the client, listen, I know you need money for your defense. I know you can't afford this. I understand why you're doing what you're doing, but I cannot participate in this. I cannot allow it. Or does the lawyer have to defer to the client on that?
I think the lawyer has to defer to the client, and he has to tell them the pros and the cons about them sitting in and listening to strategy sessions. And as you and I think that would go ahead.
I think that would explain. I don't mean to cut you off, but again, we're running short on time. I guess that would explain why this didn't break until this weekend after the trial, because the lawyers probably had to keep their mouths shut because that's what they were told to do. Basically.
Don't you have a problem with media ethics? I thought you could never buy news. I thought that was one of the bulwark of the media is you cannot purchase news. That's what I always thought. Kind of strikes that way.
We could do another show on news ethics. And that'll be an awful lot of fun. The last thing I want to hit on before we go quickly is the judge. Anybody who watched this trial or saw any news footage of this trial saw the footage of this judge absolutely pummeling the prosecutor on multiple occasions. I don't think that there was any time that he did that to the defense. He did rule against the defense in certain things, including allowing what I consider to be controversial jury instructions. But all that the same, he really, in front of the jury, scorch earthed the prosecutor. Obviously, the judge is the king or queen of his or her courtroom. And,
did he do it in front of the jury, though, Michael? I don't think he did it in front of the jury.
Oh, I think he did it in front of the jury. But whether he did or didn't, it was all.
It was on the Fifth Amendment one. He did.
I know he did at least on that.
He did it spontaneously, And let me tell you, neither one respected each other. That was so obvious. The prosecutor didn't respect the judge and vice versa. But the judge should never, as Ed just said, ever do that in front of the jury.
I agree with that.
That I don't buy your side and I'm going to be critical. Yeah.
Now, just as a quick aside on that, just as lawyers are everybody with a law license is held to the rules of professional responsibility, but judges have a separate set of rules, right? They have the judicial canons, and so they have a whole different standard for being on the bench of ethical rules that they're required to follow. Did this guy? I understand it's Wisconsin and it's not Florida, but let's just compare apples to oranges. Did he go overboard? Did the judge blow it?
Yeah, I think he did. And I think he let the prosecutor get to him. I think he could have said all the things that he said, but you just can't do it in front of the jury.
Right.
You can do it in front of the media. That's fine. But he should have excused the jury, ripped into the prosecutor and so forth. But
in front of the jury, I agree. That's to me that, and I the few times that it happened when I was a prosecutor, I got to be honest, I didn't like it. When it happened to the defense, I didn't like it because I almost felt like he was cheating, and I don't need you to cheat to help me. Don't do that. Let's have a fair fight, and let's let them do what they got to do, and don't try to influence the jury one way or the other. I mean, that's the main thing a judge has to do. If he did it in front of the jury, that was really unacceptable, no matter what he did. And I think commenting on a Fifth Amendment right should get this lawyer disbarred. I personally think this prosecutor should be disbarred, but I still don't think the judge should have done that in front of a jury. That's not right.
All right, guys, I need to wrap us up because we're just at that mark or a little bit over it. Dennis, thank you so much for coming on today. I know you're a very busy guy, and donating a part of your Monday afternoon was a great sacrifice. We appreciate it. Our audience appreciates it. I hope you'll come back some other time, and maybe we'll do that media ethics discussion on another occasion.
My pleasure.
I'll need about 4 hours for that one. Thank you so much. It's a pleasure meeting you, my friend, very much.
Thank you. Nice meeting both of you.
All right, take care, guys.
All right.
Thank you.